My main area is Dr. Wilson. I'm a doctor because I'm a lawyer. I'm a Juris Doctor, but it took me a while. I teach a course at Pace Law School to Saudi Arabian lawyers getting LLMs on Western corporate finance. And it took a while to get used to being called professor. In fact, when the dean there asked me to teach the course, my first question was, gee, do I get to be called professor? And only then I said, do I get paid? We both. The reason I've been asked to speak on this topic is it's been something I've been involved with now for a few years, ever since the November 2010 referendum in the state of Oklahoma passed by more than 70% vote, probably because it was entitled the Save Our State Amendment, and who would vote against saving your state. It was a remarkable document. It prohibited, as Dr. Wilson said, the use of the application of Sharia law and international law. And we were brought in at the request of the ACLU, who wanted a group like the New York City Bar Association. I'm a former chairman of the Committee on Foreign and Comparative Law of the New York City Bar Association. I'm on its Council on International Relations, and I've chaired the subcommittee on Islamic law of the City Bar ever since I founded it in 2005. Very briefly, the New York City Bar Association is the oldest lawyers association in the Americas, at least North America, and has over 23,000 members, mostly in New York, but also around the world. And we've done now 12 programs on Islamic law matters, including such things as jihad, honor killing, and slavery in Islamic law, fatwas from Salman Rushdie to Dow Jones, and more recently, Islam and democracy, whether Sharia law or Sharia is a threat to America. In fact, the area we focused on in our brief, this is what we filed in the 10th Circuit, which upheld the injunction, was not the First Amendment provisions, the Establishment Clause and the Free Exercise of Religion Clause, which were covered by the ACLU. We focused on the 4 or 5 other clauses of the United States Constitution that were violated. And it's sort of appropriate to be discussing this topic here in New Jersey, because New Jersey was the place where the whole movement got its impetus. There was a case called SD versus MJR, and the lower court issued an opinion which was recited to say, this court does not feel that under the circumstances that this defendant, now the defendant was the husband, was a Muslim husband of a Muslim wife, and she sought a restraining order against him for basically raping her repeatedly. And the lower court refused to issue that injunction, and this was his logic. This court does not feel that, under the circumstances, that this defendant, the husband, had a criminal desire to or intent to sexually assault or to sexually contact the plaintiff, his wife, when he did. The court believes that he was operating under his belief that it is, as the husband, his desire to have sex when and whether he wanted to was something that was consistent with his practices, and it was something that was not prohibited. Now, we have an old saying in the law, hard cases make bad law. This falls more under the rubric, dumb judges make dumb decisions. Happily, the case was quickly overturned at the appellate level in New Jersey, but by then it was of the public record, and it has been the focus of the anti-Sharia movement. And as one of the speakers earlier mentioned, the key document for that is this little piece, this Jeremiah, called Sharia, the Threat to America, an exercise in competitive analysis. This is not a lightweight document, literally or figuratively. It is the product of very good research, very serious people, including one former director of the CIA, and it's well-researched. Its descriptions of Sharia and Islamic finance are quite accurate. Its conclusions drawn therefrom, however, are less accurate. The key portion of its opening section I'll read to you to give you the basic philosophical support for the anti-Sharia movement. Those who today support Sharia and the establishment of a global Islamic state, caliphate, are perforce supporting objectives that are incompatible with the U.S. Constitution, the civil rights the Constitution guarantees, and the representative, accountable government it authorizes. In fact, Sharia's pursuit in the United States is tantamount to sedition, whether pursued through the violent form of jihad, holy war, or stealthier practices that Sharia Islamists often refer to as dawah, the call to Islam. Sharia rejects fundamental premises of American society and values. A, the bedrock proposition that the governed have a right to make law for themselves. B, the Republican democracy governed by the Constitution. C, freedom of conscience, individual liberty, including in matters of personal privacy and sexual preference. D, freedom of expression, including the liberty to analyze and criticize Sharia. E, economic liberty, including private property. F, equal treatment under the law, including that of men and women, and of Muslims and non-Muslims. G, freedom from cruel and unusual punishments, and unequivocal condemnation of terrorism, i.e. one that is based on a common sense meaning of the term and does not rationalize barbarity as legitimate resistance. And H, an abiding commitment to deflate and resolve political controversies by the ordinary mechanisms of federalism and democracy, not wanton violence. The subversion campaign known as civilization jihad must not be confused with or tolerated as a constitutionally protected form of religious practice. Its ambitions transcend what American law recognizes as the sacrosanct realm of private conscience and belief. It seeks to supplant our Constitution with its own totalitarian framework. Now, everything that it says about Sharia is true, except for the sedition, except how it applies in the United States. And the reason I want to, since this is not a lawyer's program, I won't go into the legal arguments about the full faith and credit clause, the supremacy clause, the contracts clause, due process, and the 14th Amendment we made in our brief. But I thought this audience might be better served by understanding what Sharia is and what Islamic finance is that is now very currently opposed and criticized primarily by GOP candidates for president. First of all, in due respect to Dr. Wilson, Sharia law is a tautology. Sharia includes law. Sharia is literally, the meaning of Sharia is the way or the path. It is the way in which a Muslim finds guidance to deal with all sorts of things. The word for law in Arabic is fiqh, and jurisprudence is usul al-fiqh, and they are aspects of Sharia. In fact, if you read the decisions of both the District Court of Oklahoma and the 10th Circuit Court of Appeals, as well as our brief, there's even reference to the fact that it is impermissibly vague as a basis for a penal statute. One of the principles of constitutional law is that if you're going to prohibit something and make it a crime, it has to be sufficiently clear so that the citizen can understand what they're doing wrong. Now, that is not the same thing as the dumb judge in New Jersey who didn't understand that our laws still govern no matter what someone's religious beliefs are, and that the Constitution trumps any religious practice. As the old legal maxim, your right to swing your arms freely ends at my face. And the same is true with religious practices that violate public policy and the Constitution. So the premise, as I said, of the threat is entirely wrong, that the use, application of Sharia in American courts and American law undermines or violates our system. That is no different than canonical law of the Catholic Church, ecclesiastical law of Episcopal Synod of Bishops, halakhic law of the Jewish religion, all of which apply within the ambit they are permitted to apply as non-violative of our constitutional rights. Now, to understand why I said everything that the senator said about Sharia is right, you have to understand what Sharia encompasses. Sharia is a accumulation of laws and practices and moral codes and regulations that developed for over 1,400 years, but primarily in two phases. The first 200 years, known as the formative period, began with the revelation of the Quran to the Prophet Muhammad over a 23-year period in private meetings with the Archangel Gabriel in caves, first in the city of Mecca and then in the city of Medina. Medina actually means city. The full name originally was Medina Yathrib, the city of the Prophet, named after Muhammad after he went there. And that was then followed by a 200-year period where two different sets of things happened. One was that individual schools of law were developed. They became ultimately four of them among the Sunni, named after the scholars who were at the head of them. At the same time, you had a separate